Because that's of interest to me. At some point, we understand it's quite pervasive what we have happening with gang activity and kids being recruited into this. At some point, you have to say, can we get to the head and start seeing if we can do something in it from that level? I hear oft time repeated that we know who these people are, but there is nothing we can do about it because we don't have anything to charge them with specifically, that sort of thing. But if in fact you have a case where you can show recruiting, if they are in fact members of the gang, you're saying that there is a cloak, there is under the anti-gang legislation that we can in fact go and we, the society, can go and arrest these people.
Yes, we can. Because the Anti-Gang Act, it's not a perfect piece of legislation. As a member of the Criminal Bar Association, we found several issues with it. However, it was passed and it is the law. But under the Gang Act, under the Anti-Gang Act, there is a penalty for being a gang leader. As I indicated previously, there are penalties for recruiting persons above the age of 18 into gangs. There are also penalties for recruiting children, which is defined under the Children's Act, Chapter 4601.
And child is defined at what age?
A child and juvenile are covered under the age of 18.
Gotcha. Please go ahead.
So there are penalties for the recruiting, for the aiding and abetting. There are penalties for concealing gang members. There are penalties for supplying gang members with materials. The legislation itself was comprehensive in an attempt to get at the issue of gangs. Specifically with respect to gangs in schools, if the police would have to do the investigation and come up with the material and then have the DPP look at it and then go forward from there.
The initial report, and I have not seen it contradicted even at the press conference between the minister and Tutors President David Sidanan, is that some school uniforms were in fact given to folks to come in the schoolyard and look like students here. In this case, that's the material you talk about.
Yes.
And in the case of guns being passed over to the school, over the wall and so on, as it is reported, that also, because that would fall into the area of having firearms within a certain perimeter of the schools. Is that correct?
Yes.
Would you just repeat that perimeter so we're clear on
Well,
that?
when I said the 500 meters, it was with respect to recruiting.
Okay.
However, there are provisions which prevent the sale of marijuana within certain proximity to a school. I am not sure if you can give me 30 seconds, I can pull up the firearm legislation.
Well, you can pull that up in the meantime that I remind them that next week on Brunch we will have the Deputy Commissioner of Police, Deputy Commissioner Hackett, will be sitting down here with us. We're going to be talking about a range of issues as it relates to crime here in Trinidad and Tobago. We invite you to be with us every Sunday morning from 10 until 12 o'clock as we discuss the issues of the day, as we are doing right now with attorney Raphael Morgan, criminal attorney of 7 years, and we are looking into what is the possible outcome of what has happened in Chaguanas.
Yeah, there is no provision within the Firearms Act, which is akin to the Dangerous Drugs Act, which makes it a crime to hold a firearm or have it within a certain perimeter of a school. But it is a crime to recruit a child within 500 meters of a school into a gang or to do gang-related activities.
All right. As a defense attorney, will you, if you were called upon to or hired to represent one of these minors, would you put as an argument undue influence? Is that something that we are to expect? Undue influence on a minor? I mean, because at the end of the day, what is frustrating is when these things come, and while you want to protect the rights of a citizen to due process, you get these sort of things coming up as arguments from defense attorneys like yourself.
Well, in our jurisdiction, our defenses aren't as creative as in the United States. We are set...
Creative or ridiculous?
I was trying to avoid the R word, but we aren't... our judges are a lot more conservative in terms of what they allow and in terms of what the law allows as defenses. Undue influence would work in a case of duress, where the person felt as if they had no other choice by threats or by actions of someone else but to participate. Duress would come in as a defense in those circumstances. However, if you are a willing participant, and or in this case, if the conspiracy is true, if you are a willing conspirator. Undue influence will not help you.
Good. Are you just supposed to take in a couple of phone calls this morning?
Sure, no problem.
All right, just put it out to our listeners this morning. We're talking of two cases here, that, but one specifically. Let's just stay with the school, because if we got back into that area of Mr. Allen, we have already made clear who's in charge of the area. Let's not go there. Let me just stay in the area of the children who had planned, students had planned to do this outing of a teacher, as it is reported, and a couple of other students, because it was a gang situation. Our telephone number here is 628-2250, 628-2250, and 628-9107. Repeat those numbers slowly for you. It's 628-2250 and 628-9107. Have we had anybody brought before the courts on this issue of that involved school minors getting involved in something like this, a conspiracy like this? Have we had any precedent? Has anything like this happened before? The minister said, "Never in my life have I seen it." Mr. Cinnamon said, "Never in my life have I seen it." Have you?
Not during my practice or during my years of study either. In terms of students being involved in this sort of organized criminal activity, I don't know if that is a testament to our society or to the principles that we had abided by for so long. But I have never come across it. I've come across instances of juvenile delinquency, instances of juvenile depravity, but not this sort of organized criminal activity where a teacher or a school official is being targeted, and certainly not being children being brought before the court because of it.
You can be outed. Telephone number again, 628-2250 and 628-9107. If I did that too fast, slowly, 628-2250 and 628-9107. Have you had a case at all of gang activity in school and someone charged for it? Have you seen that happen here in Trinidad now?
No. The one must remember that the Anti-Gang Act itself is a relatively new piece of legislation. It was only passed in 2011, and its use was prevalent mostly during the state of emergency, and even then it was usually meant to go after one of the more established gang leaders.
What if the gang leader himself is a minor, a so-called minor? Yes,
As I indicated before, the age of criminal culpability in Trinidad is the age of 7. So what will happen is that once the police have the evidence to prove that he's a gang leader, he ought to be charged as the gang leader, and he ought to be prosecuted as the gang leader. What the differences between himself and an adult would be: one, where he's housed until he turns the age of 18, if he is convicted, or even while he is held pending bail, and two, the penalties that are available to the court if he is convicted. Because as it stands, if he's a child, there may be different considerations as opposed to an adult.
You are an attorney in one of your, and you were hired in this case, as I said, and your client said, "Listen, I want to turn evidence. I want to talk to you. I want to tell you about who's responsible for this, but I need some guarantees for my safety." And you, of course, have a concern for your client. What sort of things you would ask for? Because it becomes a real issue. Half the crimes are solved by somebody whistling, as it were. And this being the case, this child has a community to go back to. He has to go to school, and he's open to these elements. What sort of thing would you be demanding be put in place for him?
Well, in those circumstances, I don't see any other choice having regard to the extent, if we are speaking about this situation, having regard to the extent that they were prepared to go, the only choice that person would have would be to go into witness protection. Because other than that, there have been instances of witnesses being taken out, for want of a better phrase, in the past, and in particular where the penalties for being a gang leader, and not just the criminal penalties, but the other societal effects and the gang leader's henchmen or the gang's other minions may want to come after you. I think the only choice that the only option that one can seek in that instance would be to ask for witness protection.
That expands the conversation into a whole different direction, because on the one hand, it is a reality of something that will be considered if a child decides, or his parents decide, I'm going to tell you, cooperate to get this done. We have to think about the welfare of the child.
Yes.
But it's not even the child you asking for the witness protection program. Now you're asking for the entire family to go with him.
It would have to be the entire family, because it is open as to most criminals. If they can't get to you, they may seek to get to someone close to you in order to influence your testimony. So it may be, if that option is being pursued, hypothetically, that you would have to seek witness protection for the entire family. With respect, they are charged and tried as adults. We don't have the distinction here where we charge some as minors and charge some as adults. They face the full criminal offenses. The difference is in the penalties that are available to the court. So for example, if someone under the age of 18 commits the offense of murder, they do not face the death penalty. All the other options are available to the court in terms of sentencing, but what is taken off is the death penalty, because the society recognizes that persons under the age of 18 are afforded a certain level of protection because of their mental development may not be that of an adult.
I agree with you, and you would understand that what we have done is this morning not just deal with the situation there. I have inquired of the attorney a number of things as to complicity, as to the those who are in gangs. I have raised the question of if we have the legislation and it's a case of enforcement. Well, he made it very clear the anti-gang legislation does in fact cover that, does it not?
It does. In terms of the other general powers of the police has very wide powers. Our policing legislation may not be as advanced as that of the UK or as that of the United States, but however, the police does have wide powers and wide areas of legislation which they can use for crime detection. The issue of crime, what as a society, and if I may venture from my own legal expertise, as a society, we have to understand that crime is a social problem. The police by themselves cannot go and clean up crime. It starts in various levels and in various areas that have to work together in concert to remove these negative elements out of society. So even though the police may have certain powers, and granted, a lay person, because you are not involved in it every day, may not be aware of all of the powers that the police has, and which is why we are answering your question. We also have to understand, as citizens, take away all our titles, take away all our offices, but we all have to work together to identify the negative elements and to work together in concert to root them out. The police can't do it on their own.
And that's one of the reasons we'll be having the Deputy Commissioner up next week, because we'll be talking about the public feeling comfortable to be the extension of the police officer, being their eyes and ears, but there must be that question of trust. Yes. And we will discuss that next week.
I must disagree, sir, because as it stands, as I explained before, from the age of 7, you can be charged with a criminal offense. Any criminal offense that is on our books, save and except for any statutory restriction that is put in place. The only difference between a minor, which is someone under the age of 18, and someone above the age of 18 is their treatment while in custody and the penalties that are available to the court once sentencing comes. It's apparent from the calls, and it's something that the government and all stakeholders ought to do, is to educate us, Trinidad and Tobago, as a society, as to what pertains when people are arrested. Various classes of people, minors, adults, elderly persons, so that the questions of police brutality, the questions of inequality of treatment, these questions are answered before a prejudice is pervading in the minds of the citizens, that somehow one class or one age group is afforded beneficial treatment, when in fact, save and except for questions of sentence and treatment, and they aren't.